Hello friends, today I tell you about Contempt of Courts Act 1971 and its repercussions and what types of contempts are there. And the biggest question for today is, are the courts in India becoming toothless tigers? Toothless tiger is something like a tiger which doesn't have teeth and it cannot hunt its prey. So therefore it will become very, domestic. It will not be a wild animal anymore. In the same way, the courts have been given with the sweeping powers under the Contempt of Courts Act. Whichever court passes any of the orders or judgments, then those have to be implemented successfully by the executive, which is responsible for its implementation. And if the executive does not follow the rule of law and violates the judgments and orders of the whatever courts, the trial courts or the high courts or the Supreme Court, deliberately and intentionally, then that will be considered as a contempt. And there are two types of contempts. Number one is civil contempt, which is defined in the section B of the Contempt of Courts Act, and which is primarily constitutes an offence when somebody violates deliberately an order passed by the court, respective court. The order of the judgment pronounced by the respective court is violated deliberately and intentionally, then it will become a civil contempt. Alright, and the punishment is defined in the sections 10 to 12 of the Contempt of Courts Act 1971, and accordingly the person will be punished for 6 months with 2,000 rupees fine. In the same way, the criminal contempt is defined in the section 2C, which constitutes when the offence is constituted is if a person, intentionally or deliberately, writes something against the judiciary or the sitting judges, or talks ill in the social media or any of the media or broadcasting channels or whatever, the way of publication, or uttering some kind of abusive words. If he misbehaves in the court, if he violates the majesty of the court, that is treated as criminal contempt. And one more thing, if somebody is interfering with the dispensation of justice, obstructing, is not allowing the court to do justice to the parties, if one of the parties obstructing or the council is obstructing, then also it will constitute a criminal contempt. Recently the Delhi High Court has punished an advocate. They have sentenced, the court has sentenced the advocate for 4 months in jail and 2 months of 4 months in jail and 2,000 rupees of fine. So there are a number of examples like this. So what I am telling you is about the contempt, civil and criminal. Now the criminal contempt punishment is defined in the section 14 of the Contempt of Courts Act. The punishment is same, 6 months jail and 2,000 rupees of fine. So which article is the one which provides the sweeping powers to the courts, constitutional courts? Article 214 and 215 have empowered the honorable high courts, particularly the 215 article, providing them the inherent jurisdiction, and the high courts being court of record, they can punish for the contempt of themselves as well as the subordinate courts as well as the superior courts. The jurisdiction, the inherent jurisdiction of high courts is very wide. So anybody who the contempt or whomsoever is violating the orders or judgments of the trial courts as well as the high courts as well as the Supreme Court, all of these people can be punished in the high court. Whereas the Supreme Court can punish for the contempt of itself under Article 129. It do not usually punish for the contempt of lower courts and the high court. If they are coming in the appeal form or SLP form, then only they will consider it. Otherwise, directly they won't punish. So even the Honorable Supreme Court under the Article 129 have got omnibus and sweeping powers to punish the contempt laws under civil as well as the criminal. So they have inherent jurisdiction. One of such examples is Justice Kannan, who has been sentenced. He's a sitting judge of the Calcutta High Court who has been sentenced to 6 months in jail. So it has become the first time in the history of the entire judiciary that some sitting judge has been sentenced, because he has passed orders against the judicial decorum and against the Honorable Supreme Court, which has irritated the Honorable Supreme Court, and it was treated as criminal contempt. Numerous opportunities have been given for Justice Kannan to apologize, but he has stood with his stand, and he never did that. So therefore, the contempt has been attracted, and he has been sentenced. So in the same way, there are numerous judgments. I think it's Balwant Bhai Somabhai. In this judgment, Honorable Supreme Court has categorically held that if the contemnor apologizes just for the fear that he is getting convicted by the Honorable High Court or Supreme Court, that apology should be rejected forthwith. Because the contemnor is apologizing, it's an unqualified apology before the Constitutional Court just for the fear, but not out of real regret. So therefore apology also which is tendered can be rejected. So contempt itself is a very dangerous thing, and I must be very obliged and thankful to various high courts in the country like Patna High Court, and even in fact Mumbai High Court, Bombay High Court as well, and Madhya Pradesh High Court. The sitting judges are extraordinary. They have great conviction for their profession. Like the executive will be always on their toes. Even the chief secretaries and the DGPs are not spared in these courts. They are, if the contemnor even happens to be a DGP or a chief secretary, they will be dealt with an iron hand in these kind of courts. They are very good, even the Delhi High Court also. But there are some high courts which need to improve as far as this kind of thing is concerned in the Contempt of Courts Act. Other day I was hearing one of my colleagues arguing a matter in the Telangana High Court also. Even he was very much worried, and even he brought to the bench the same grievance that the court has to deal with the contemnors with an iron hand. That is very important. Otherwise, the courts will become toothless tigers. They will be going on passing orders, and nobody is going to implement them. It will be just, of no use. Alright, unless and until there is value for the court and its orders are taken up seriously, and the executive is going to implement it seriously, no justice can be done. In order to meet the ends of justice, the courts sit almost 24/7, I should say. A lot of people think the courts sit only for 8 hours or 6 or 7 hours. That's wrong. Because the judge job is a 24/7 job. Just like a police officer job is 24/7 job. Even a doctor's job is a 24/7 job. Even in the midnight they get a call and they have to do night duties, and they have to wake up and they have to rush immediately. No other professional can do such kind of work. It's not that easy. So the judges, they read the file the whole night and sometimes the whole of their life without any vacations. So this is what we need to understand. Judges do a lot of hard work, and knowledge wise they are far more superior than advocates. They know far better. And yes, if some counsel comes with well prepared preparation, and he represents and he puts forward a good argument, judges across the country, no matter it's trial court or even the Honorable Supreme Court, they appreciate that kind of counsel, because that is what they are expecting. Good argument and sensible argument on the question of law, right on the money. It has to be on the question of law, not more on facts and all. If you go to the constitutional courts, they are not much interested. Even in the lower court also, if you want to prove some kind of fact, that is only through the facts in issue and relevant facts. These are the two things on which one has to prove. So one has to prove the facts only by way of evidence. So that need to be understood, my dear friends. And as I told you, the courts must deal with the Contempt of Courts Act very seriously. And in fact, there was one more judgment. I didn't get it, I forgot it, but the Honorable Supreme Court has categorically held that the whole and sole purpose of enacting this Contempt of Courts Act and getting into the statute book is to do justice and to increase the confidence, to inspire confidence in the people, in the judiciary. That is the main motto and that is the main agenda. So that has to be protected. Whenever there is a kind of contempt, the courts have to deal with it very seriously, whether it is the trial court, high court or the Supreme Court. And thankfully the Honorable Supreme Court always takes the contempt very seriously. If somebody is doing criminal contempt in the Honorable Supreme Court, it is treated as a contempt on the face of the Honorable Court. Recently one more order has come through the Honorable Supreme Court. The Honorable Supreme Court has granted bail in some Gujarat businessman's case. His name is I forgot, Somabhai, Kandubai something. So in that case, he has been granted anticipatory bail. But in spite of that anticipatory bail, the police has moved a custody petition in the trial court, and they So therefore the judicial magistrate as well as even the police officer both were held for contempt on the face of the Honorable Supreme Court, and they have been convicted. And they have been called to the Supreme Court along with their suitcases, so that from there itself they can go to the jail. But they have apologized, and the executive, that is the government of Gujarat, through its Solicitor General, Learned Counsel Tushar Mehta, he has represented and he has said we are already taking departmental action. Therefore, he begged the Honorable Supreme Court to drop the action. Otherwise, it was a very serious issue, and the Honorable Supreme Court has taken it very seriously. So, it's all about contempt, my dear friends. So, that is the reason why people need to have faith in the judiciary, and therefore, contempt is a very biggest weapon for the courts. So, they have to utilize it properly. Otherwise, seriously. Otherwise, with lot of conviction and lot of seriousness. Otherwise, people will not have faith. I've seen lot of executives. Even the IAS officers or cadre of the secretaries and even the commissioners in various municipal corporations as well as the police commissioners, they don't have any respect for the courts because they brazenly flout the orders and judgments of the Supreme Court as well as the High Courts, and they say, okay, we'll apologize. It's a casual attitude. We'll apologize. What will the judge will hardly with reprimanders and in reverse. This is what the attitude they have. It's very wrong because we need to respect our courts, because judiciary is the greatest pillar of our country. When the people in the executive as well as the legislature as well as even the media or even the common man, when every of these people commit mistakes, everybody comes and looks up to the judiciary for justice. Doing justice is not the job of the executive nor legislatives. It's the job of the judiciary. They are professionals in dispensation of justice. So therefore that domain has to be protected by the Contempt of Courts Act, giving seriousness, considering its seriousness, and it has to be implemented properly. All the judgments and the orders of these courts, particularly the constitutional courts, have to be implemented by tooth and nail. This is what I want to say. Otherwise, it will become a toothless tiger and nobody will get scared. Like you're playing with your pet dog in your home, you can start playing with that pet tiger also, which doesn't have any teeth. That's all, my dear friends. Thank you.